on is race as a factor in admissions. I chose this topic because I felt that it was relevant to our age group since we are in college, and it's also something interesting for teachers to learn. This is for the teaching professional, and it is created by myself, Kylie Fellows. So I first wanted to go over the term affirmative action. The definition of affirmative action is it is the policy of favoring members of a disadvantaged group who suffer from discrimination within a culture. It is used to achieve goals of increasing access to education, promoting diversity, bridging inequalities, and redressing past wrongs. And the reason I bring up this term is because it's kind of the term used as race is a factor in admissions. It's called affirmative action. And it is used in employment, and it is used in many college admissions decisions, as you will see in the coming legal cases and slides. The next thing we're just going to quickly review is the Equal Protection Clause, because it comes up a lot in the legal cases to come. So the Equal Protection Clause is part of the 14th Amendment of the U.S. Constitution. It prohibits states from denying anything the equal protection of the laws. It means that you must treat individuals in the same manner as others in the similar conditions or situations. And to make a point, it's not intended to provide equality among individuals, but it's only equal application of the laws. So I'll begin by going over 5 legal cases that have to do with affirmative action and whether or not race is an actual factor in admissions decisions for certain colleges. The first case that I'll be talking about is the Regents of the University of California versus Bake. This happened in 1978. The next one is Hopwood versus Texas, and this happened in 1996. The next case is Gratz versus Bollinger. This happened in 2003. And Grutter versus Bollinger, which has also happened in 2003. And then the last case I'll be discussing, which is also a current event, is the Fisher versus University of Texas at Austin, which started in 2013 and is still ongoing to today. So the first case is the Regents of the University of California versus Bake that happened in 1978. The case, the respondent was Alan Bake, who was a white 35-year-old applicant to the University of California, Davis Medical School. This school reserved 16 spots out of the 100 in any given class for disadvantaged minorities as part of the university's affirmative action program to address any unfair minority exclusions from the medical profession. Bake's qualifications, which include his college GPA and test scores, exceeded those of any of the minority students admitted in the 2 years Bake's applications were rejected. Bake contended, first in the California courts, then in the Supreme Court, that he was excluded from admission solely on the basis of race. He sued the university saying that his denial of admission was on racial grounds and that it violated the Equal Protection Clause of the 14th Amendment to the U.S. Constitution. So, the court ended up ruling that the medical school at the University of California at Davis could not reserve slots with separate admission standards for minority applications because it did violate the Equal Protection Clause. It also ruled that colleges could consider race and ethnicity in admissions decisions as long as they did not use quotas. And an example of a quota is setting aside a number of class seats for minorities. The next case I'm going to talk about is the Hopwood versus Texas case that happened in 1996. In 1992, Cheryl Hopwood applied for admission to the University of Texas School of Law. She had an undergraduate GPA of 3.8 and achieved a score of 160 on the LSAT. When these accomplishments were combined, Hopwood's scores placed her in the university's presumptive admit category of applicants. The University of Texas, however, operated a dual admission system that required lower admission qualifications for favored minorities than for all other races, and since she was white, this put her in the different category. Even though Hopwood possessed excellent qualifications, the university denied her admission and instead offered admission to 62 students from the favored minority track. Of those 62 admitted students, Cheryl Hopwood held a better combined LSAT and GPA score than all but 9 of the other students. So in turn, she ended up filing a lawsuit against the university, and it ended up being a historic victory in the Fifth Circuit Court of Appeals. The Fifth Circuit ruled ruling barred all use of racial preferences in university admissions in the states under that court's jurisdiction. Since the Supreme Court declined to hear the case, the victory became constitutional law in the Fifth Circuit, and universities in the states of Texas, Louisiana, and Mississippi were prohibited from using racial preferences for over 7 years. So basically, at the end, the ruling affirmative action unconstitutional, and it also led to the top 10% law, which we'll talk about in the next case. So these next two cases that I'm going to talk about, I put together because they were ruled the most important since the Bake case 25 years ago. The first one is Gratz versus Bollinger. This happened at the University of Michigan, who received a high volume of applicants each year to its College of Literature, Science, and the Arts, and in order to help with admissions decisions, the university implemented a point system. This point system is out of 100 points, and basically a student that is from an underrepresented group automatically receives 20 points towards his or her overall score. The groups of students typically come from African American, Hispanic, and Native American backgrounds. A student with extraordinary artistic talent receives 5 points under the admission system. Also, every student that is from an underrepresented group and is otherwise qualified is typically accepted into the school. A group of white students that were determined qualified by the university were denied admission, and that is where this case has gone. At the time that Jennifer Gratz applied, the university analyzed prospective applicants under a grid system. Gratz had a combined ACT and GPA scores that placed her just outside of that presumptive admit portion of the grid that used to analyze her results. But, however, the university had a separate grid for analyzing potential applicants it considered underrepresented minorities. On this second grid, Gratz's score placed her far above the minimum threshold of automatic admissions. So Gratz's achievements gave her a competitive chance of gaining admission, but if the university had considered Gratz as a favored minority applicant, she would have had a 100% chance of gaining acceptance to the university. So for Gratz, race was the difference between rejection and acceptance, which is a huge deal. The Supreme Court reasoned that the point system, assigning points based on outward characteristics, treated applicants in a manner that prized their race over their individual accomplishments, and that the failure of the university to treat applicants as individuals constituted a violation of the 14th Amendment. And now the next case, Grutter versus Bollinger, also happened in 2003. With this, it was the University of Michigan School of Law that used a grid system to evaluate potential candidates for the admission, just like the undergrad admission process. The respondent's name was Barbara Grutter, and she was a white female applicant. She had a less than 9% chance of admission on the grid that they used. However, if under the same system, a favored minority applicant with the same score had a 100% chance of gaining admission. So, as with Gratz, Grutter's race was the difference between automatic acceptance and automatic rejection. The Supreme Court reasoned, actually, that fostering diversity in higher education is a compelling government interest. So, because this was higher education law school, they felt that it was in its constitutional rights to consider applicants' race and ethnicity, because it also did so in a holistic review and not simply just awarding points based on race and ethnicity like the undergraduates program had done. Before we move on to this last legal case, it is important to note that the 2003 cases, both of them, the Supreme Court ruled that the use of affirmative action in school admission is constitutional if it treats race as one factor among many. Its purpose is to achieve a diverse class, and it does not substitute for individualized review of the applicant, but is unconstitutional if it automatically increases an applicant's chances over others simply because of his or her race. Now on to the final case, Fisher versus University of Texas at Austin, starting in 2013 and continuing on to today. So as discussed earlier, because of Hopwood, the Texas legislature passed the Texas 10% plan because of the fall off of the number of African Americans and Latinos in Texas schools. Under this plan, students graduating in the top 10% of their high school classes were guaranteed admission at the Texas state school of their choice. Eventually, not enough minorities were being accepted, so then race was beginning to be considered in its holistic applicant evaluations. The respondent in this case is Abigail N. Fisher, a Caucasian female who applied for undergraduate admission to the University of Texas in 2008. Fisher was not in the top 10% of her class, so she competed for admission with other non-top 10% in-state applicants. The University of Texas denied Fisher's application. So Fisher filed suit against the university and other related defendants, claiming that the university's use of race as a consideration in admission decisions was in violation of the Equal Protection Clause of the 14th Amendment. The university argued that its use of race was a narrowly tailored means of pursuing greater diversity. The district court decided in favor of the University of Texas, and the United States Court of Appeals for the Fifth Circuit affirmed the district court's decision. Fisher appealed the appellate court's decision and is now under the Supreme Court for the second time currently. But before it came to the second court, the first Supreme Court, way back in 2013, ruled that these lower courts needed to have more evidence and apply strict scrutiny, and not give colleges deference in reviews of challenges to the consideration of race and ethnicity in admissions decisions. And that's when the Fifth Circuit Court came back and said they ruled in favor of the university and that it was okay to do so to obtain greater diversity. In essence, this case the ruling has raised the bar for colleges in terms of how to justify the consideration of race and ethnicity in admissions, but it did not bar the use of racial preference. Now that it's back at the Supreme Court, it is a current event. It started in June 2015 again to hear it again, and they announced that they would hear the case again, hoping to have a decision by the following June. But because of the current event of Justice Scalia's death, it now seems that the decision will be delayed. So as mentioned before, the Fisher case is still ongoing and a current event. The death of Supreme Court Justice Antonin Scalia now might change the vote of the Fisher case, because he was actually for Fisher and against affirmative action. So at a minimum, the decision of this court case is delayed. With his death, there is now only 8 on the High Court. It was a 5-4 vote. Now it's a 4-4 tie, which means Fisher can lose and the university can use race in admission process. So it will be brought to the lower courts if it's decided this year, and if there's no replacement for Justice Scalia, obviously. So I'm now going to show you a video that I found on YouTube. It was published February 15, 2016. It's about Justice Scalia's death, and it provides some insight as to what's going to happen now because of his death, especially with the case we were just talking about, the Fisher case. I also learned from the video, which you will see, that it is not going to be 8 on the higher court, that it will be 7 because a justice also renounced being part of the case.
A legal case concerning the affirmative action admissions policy at the University of Texas is still before the U.S. Supreme Court.
The suit was brought by Abigail Fisher, who sued the university for using race as a factor in college admissions. This afternoon, I spoke with UT law professor Lino Graglia about the impact the death of Justice Scalia could have on the Fisher case.
We have the Fisher case still out there, and what does his death do to this case, do you believe?
Well, you certainly could have been sure that he would have voted in favor of Fisher. That is, he would have voted against affirmative action, against race preference. He was very strong that the Constitution that should not permit the government to deal with people on the basis of race. He was very strong and predictable. But that is also true of Sotomayor, of Ginsburg, of Kagan. That is, there is no way that they're ever going to vote to disallow race preference. That's not going to happen. Scalia and Thomas, you could say the same thing in the other direction.
Well, I believe one of the justices has recused herself from this case.
Yes, Kagan.
So it could come down to a decision ultimately without those two, right?
So now, on this case, it'll be effectively a 7-judge court.
Professor Graglia told me in the Supreme Court 5 justices is a quorum. He says he and Justice Scalia were good friends and predicted his replacement will not be sworn in until after President Obama leaves office.
So now I'd like to give a scenario and ask a question to pose to the class. A white male had a 3.85 GPA and did not get into Rutgers University, but an African American male who had a 3.6 got into Rutgers. In essence, someone who had a higher GPA did not get into his school because of his race and did not fit the diversity quota. Do you find this to be fair? So clearly this is an opinion question, but here are some reasons it would be considered fair. So the pros, or the reasons affirmative action is considered fair, is because it ensures diversity is created and maintained in schools and the workplace. It creates tolerant communities by exposing people to a variety of cultures different from their own. It also gives people an equal playing field. It's especially important for those who are disadvantaged and live in areas where there are not many opportunities to advance. And the last pro that I would say with this kind of reasoning is that it compensates for the fact that some races started late in the race due to many years of oppression in the past, which colleges have used as their reasoning for affirmative action to help level the playing field again. So now that we've reviewed the pros or the reasons why affirmative action is considered fair, I have another question to pose to the class. If schools do continue to use affirmative action, do you feel that it could lead to lowering the standards for grades and qualifications to get into schools? Or do you feel it doesn't impact the overall level of achievement? This is another opinion question, but keep in mind that there is some evidence that the standards can be lowered in the cases we just reviewed, along with quite a few other cons to affirmative action that I'll bring up in the next slide. So the cons, or the reasons affirmative action is deemed unfair and can lead to this lowering standard of achievement, is one, it's reverse discrimination. Past discrimination against minority groups does not justify present discrimination against non-minorities, which is occurring in these affirmative action cases. All people are equal under the laws of the United States, and we need to be reminded of that. In addition, this lowering level of achievement comes from the idea that it's destroying the idea of meritocracy by allowing affirmative action. It puts race as the dominant factor in admissions, and it should be that the best people should be accepted regardless of their race. If they have the qualifications, they should be allowed to go to the school that they want. Another con is that students accepted because of affirmative action are usually not fully ready for the task. It's not good for the university, and it's also not good for the students because it lowers self-esteem. Some more cons to why affirmative action is considered unfair is it reinforces stereotypes and racism. People given a position purely because of affirmative action often aren't qualified. And it also is this perpetuated idea that all people of that race are stupid because if one's not qualified, it is given that other men not qualified, which isn't the case ever really, but that's what it comes off as. And it presupposes that all people of the same skin color are from the lower class and in turn need help, that they need this grid system and extra qualifications to get them into these schools. It also does not guarantee diversity of opinion by having affirmative action. Having people of different races or ethnicities and the same skin color does not mean they will be the same in opinion or even culture. So to wrap up my presentation and what I discussed, there have been quite a few legal cases that put the constitutionality of affirmative action at question, which we have seen. Many colleges do consider race when reviewing applications as long as there is not a point system that clearly puts someone of a favored race at an advantage without considering individual accomplishments, which we also saw. We also discussed that there are pros and cons to affirmative action depending on people's beliefs. And it has been shown that many say that diversity in itself is not a compelling justification for the use of racial preferences. The affirmative action debate is obviously still at large, as we can see with the current event, and that is something that we will see in the future, whether it becomes a valid thing for every college or if it ends up being turned around where colleges cannot use it.